Big U was already sitting in federal custody, preparing for a trial that could determine whether he ever comes home. But now, federal prosecutors claim he may have tried to stop one of their witnesses from ever reaching the courtroom. According to a newly filed federal indictment, Eugene Big U Henley allegedly approached two inmates, asked about the location of a government witness, and offered money to have that person killed or seriously harmed. And prosecutors say this was allegedly done for one reason: to prevent the witness from testifying in Big U's upcoming federal trial. But after reading the new paperwork, this story leaves behind several major questions. Who are the two inmates? How did federal investigators learn about the alleged conversation? Was Big U being recorded? And what could victim number one possibly know that allegedly made their testimony this important? Because the new federal paperwork does not simply add another allegation to Big U's existing case. Prosecutors are now claiming that while Big U was already behind bars, the federal trial itself allegedly became the target of a new crime. On July 29, 2026, a federal grand jury returned a second superseding indictment against Big U and several of his co-defendants. A superseding indictment is an updated version of an existing indictment. But this was not just a minor correction or a few words being changed. The Justice Department says 7 additional felony charges were added against Big U. Those new counts include wire fraud allegations and a conspiracy charge involving interstate transportation. But the most serious new development appears in counts 47 through 50. Those 4 charges center on an alleged jailhouse plot involving 2 inmates and 1 unidentified government witness. The date listed in the indictment is June 10, 2026. According to the Justice Department, Big U believed the witness was being held inside a particular housing unit. Prosecutors claim he approached 2 inmates and asked questions about the layout of that unit. That detail changes the entire tone of the allegation. The government is not simply accusing Big U of saying he was angry with the witness. Prosecutors are claiming he allegedly wanted information about where that person was being held and how the housing unit was arranged. Then comes the most serious accusation. The Justice Department claims Big U offered to pay the 2 inmates to kill or physically harm the witness. That person is identified in the court paperwork only as victim number 1. Prosecutors allege the purpose was to prevent victim number 1 from testifying against Big U and other defendants at their upcoming federal trial. Now, there is an important distinction between the Justice Department's announcement and the exact wording inside the indictment. The Justice Department provides the detailed description involving the housing unit layout and the alleged payment offer. The indictment itself uses more technical legal language, but when you break that language down, the accusation is still extremely serious. Page 74 contains counts 47 and 48. Those are 2 counts of solicitation to commit a crime of violence. The first person Big U allegedly approached is identified only as solicited individual number 1. The second person is identified as solicited individual number 2. Both allegations are dated June 10, 2026. Prosecutors claim Big U attempted to persuade each individual to engage in conduct involving physical force against victim number 1. In plain English, the government is accusing Big U of separately approaching 2 people and attempting to convince them to commit violence against a witness. That appears to explain why there are 2 separate solicitation charges. One charge is connected to solicited individual number 1. The second charge is connected to solicited individual number 2. But the next page may create an even bigger problem for the defense. Page 75 contains counts 49 and 50. Those are 2 attempted witness tampering charges. According to the indictment, Big U allegedly attempted to intimidate, threaten, or corruptly persuade the same 2 individuals with the intention of influencing, delaying, or preventing victim number 1's testimony. And prosecutors specifically connect that alleged conduct to Big U's upcoming federal trial. That is the part viewers need to understand. The government is not claiming this involved a random personal dispute inside the jail. Prosecutors are alleging that Big U tried to interfere with the proceeding that will decide his own federal case. But the newly filed indictment still does not publicly reveal the strongest evidence behind the allegations. It does not identify victim number 1 by name, it does not identify the 2 inmates, and it does not explain exactly how federal investigators learned about the alleged plot. That missing evidence could become the most important part of this story. If the government recorded the conversation, the exact words and context could be played in court. If there is no recording, prosecutors may depend heavily on the testimony of the two inmates, and that would open the door to major questions about credibility, motives, and whether either person received or hopes to receive some type of benefit from federal authorities. That does not mean their information is false, but the defense would almost certainly investigate whether either witness expects assistance with charges, sentencing, housing, protection, or another federal matter. Big U's attorneys may also challenge what he allegedly intended. There is a major difference between an angry statement, reckless jailhouse talk, and a genuine attempt to arrange violence against a federal witness. Prosecutors will have to establish that the alleged statements were serious. They will have to prove Big U intended for the two individuals to act, and they will have to show that his alleged conduct crossed the line from speech into criminal solicitation and attempted witness tampering. That is why any recording, message, payment record, surveillance footage, or cooperating witness testimony could become critical. The indictment tells the public what prosecutors allege. It does not yet show the public everything prosecutors claim they can prove. There is also no public allegation that victim number one was actually attacked. Authorities have not announced that either inmate accepted payment, and the available court paperwork does not say that the alleged plan was carried out. But that alone would not necessarily defeat the new charges. Federal prosecutors can charge solicitation and attempted witness tampering even when the alleged violence never takes place. The government's position is that the alleged attempt itself became a separate federal crime, and the timing could make the allegation especially damaging. Big U has remained in federal custody since March of 2025. His joint trial with 6 co-defendants is currently scheduled for February of 2027. Prosecutors claim the alleged witness plot occurred on June 10, 2026, while Big U was already detained and preparing for that trial. If the government proves its allegation, prosecutors may argue that being locked up did not stop Big U from allegedly attempting to influence what happened in the case. They may attempt to present this as evidence that he was still trying to exercise control from inside federal custody. But it is important to keep the case in its proper legal position. An indictment is an accusation. It is not a conviction. Big U remains presumed innocent unless prosecutors prove the charges beyond a reasonable doubt. His defense will have an opportunity to examine the government's evidence, question the two alleged inmates, challenge any recordings, and dispute how prosecutors interpreted the alleged conversation. And Big U's attorneys may argue that the government is presenting an incomplete or misleading version of what was actually said. But the potential penalties show how seriously federal law treats this type of allegation. According to the Justice Department, each newly added witness tampering count carries a statutory maximum sentence of life in federal prison. That does not mean Big U would automatically receive a life sentence. Any actual sentence would depend on which charges, if any, result in convictions, along with federal sentencing law, guideline calculations, and the judge's final decision. But this still creates an enormous new threat. Big U was already fighting for his freedom in the larger federal case. Now, he must also defend himself against allegations that he tried to prevent a witness from helping the government prove that case. And the most important details remain hidden. We do not yet know who victim number one is. We do not know precisely what that witness is expected to say. And we do not know whether prosecutors possess a recording that captures Big U's alleged words directly. Those details could determine whether this becomes one of the government's strongest allegations or one of the most heavily disputed parts of the entire case. But here is what the new paperwork officially adds. Counts 47 and 48 accuse Big U of soliciting 2 separate individuals in connection with alleged violence against victim number one. Counts 49 and 50 accuse him of attempting to prevent that witness from testifying at his upcoming federal trial. And according to the Justice Department, the alleged plan involved questions about the witness's housing unit and an offer of payment to have that person killed or physically harmed. So the story is no longer only about what prosecutors claim Big U did before his arrest. The government is now alleging that after Big U was locked up, and while his federal case was still moving toward trial, he attempted to change the outcome by targeting one of the people expected to testify. But the indictment only gives us the accusation. The real battle will be over the evidence. Because if prosecutors have a clear recording, messages, payment discussions, or multiple witnesses telling the same story, Big U could face a serious new obstacle heading into trial. But if this case depends mainly on the unrecorded word of two inmates seeking benefits, the defense will have an obvious credibility fight to take directly to the jury. Either way, this new indictment has raised the stakes. Big U was already preparing to defend himself against the federal government. Now prosecutors claim he also tried to silence one of the people helping them build their case.